So good afternoon and welcome to today's session, IR35 and off-payroll working 1 year on. I'm Fiona Herrell. I'm a partner in the Employment and Immigration team here at Brodie's, and I'm delighted to be joined by Karen Davidson, a partner in our corporate tax and incentives team. By signing up for today's session, we have assumed that you have a certain base knowledge of IR35 and the changes that came into force in April 2021 as a result of the off-payroll working legislation. But before we get into the session, we thought we'd just do a really quick, and I mean really quick, recap of those changes, so just so that they are fresh in your mind if it's not something that you're looking at every day. So under IR35, which was a piece of anti-avoidance tax legislation, and that was designed to tax disguised employment, the obligation to assess status for tax purposes and to deduct any taxes that were due sat with the personal service company in a scenario where a client was engaging a worker via a PSC. So we can see that on the left-hand side of this slide. Similarly, where the client was engaging a third party who were then engaging with the PSC and ultimately therefore the worker, again, you'll see that the obligation to assess status and to deduct any payroll taxes that were due again sat with the PSC. So from the client's perspective, from the end user's perspective, no risk here, because ultimately it was for the PSC to do all of that, and to the extent that they didn't do it or they did it and they got it wrong, then it was going to be for HMRC to go to the PSC to sort that out and not to go to the client. HMRC's perception was that there was sort of mass non-compliance with IR35 by workers and their PSCs, and that was resulting in a huge amount of lost tax. At one point, HMRC thought that it was only 10% compliance with IR35. And of course, HMRC was never going to be in a position to go after all these individual PSC companies and undertake investigations in relation to their compliance with IR35. They just wouldn't have had the resources that would have been necessary to do that. So what we saw from 6th of April 2021 was a shift, as we can see on this slide. So now, under this new regime, we can see that the obligation to assess status sits with the client, and then to the extent that the individual worker is considered to be or would be considered to be an employee for tax purposes if they were engaged directly by the client then also has the obligation to operate payroll and deduct taxes in respect of that worker and the payments that it makes to that worker. That's what we see on the left-hand side of the slide. On the right-hand side of the slide, we see a more complex contractual chain where we've got the third party as well as the PSC. And for simplicity, we've only recorded one third party in this slide, but of course there could be multiple third parties sitting in that contractual chain. In that sort of scenario, the obligation to assess status sits with the client. But the obligation to operate payroll deductions and taxes in respect of payments made to that PSC, it sits with the third party, and for that purpose they're called the fee payer. So if we're talking about the fee payer in the session, that is who we are talking about. Remember that these changes only apply to clients in the private sector, which are medium or large businesses, and there are various thresholds that have to be met in order to fall into that category. Also, if the client entity sits as part of a group, then it has to be, whether or not it's medium or large, sits or has to be assessed rather at a group level rather than looking at each of the subsidiaries on an individual basis. So these changes that have been brought about by this new legislation have undoubtedly had a significant impact for medium and large enterprises in the private sector, which engage with contractors and other off-payroll workers. We'll just sort of recap on what the position is on the next slide, please. Many businesses have had to change their hiring practices and their policies, for example. So some we've seen have moved to a model where they no longer engage off-payroll workers, and they've sort of gone to a position where everybody's engaged as staff. Others perhaps are engaging with umbrella companies. Others are using employment businesses, outsourcing the status determination assessments to third parties. So there's all sorts of different arrangements arrangements being operated by different companies, there's no getting away from the fact that there has been an increased administrative burden for businesses as a result of this change, including, as I said, rolling out policies, but then also training for hiring managers who are involved in order to try and ensure that there is compliance with the new regime. It has always been controversial, and that controversy continues. We've seen a number of IR35 cases coming through the courts. They're all really fact specific, so it's not possible to look at one case and take away any sort of general principles from it, but it is interesting to see that those cases are continuing. It's also been interesting because the public sector had these changes or similar changes introduced before the private sector. So for the public sector, the changes came in 2017. And what we've seen just in the course of the last year or so is HMRC issuing tax bills and penalties to a number of governmental departments who have been found to have not complied with the changes within the public sector. So Department of Work and Pensions was billed 87.9 million, Home Office 33.5 million, HM Court and Tribunal Service, which of course includes the Employment Tribunal, 12.5 million, and the Ministry of Justice 72 million plus an additional 15 million penalty because HMRC considered that the MOJ had been careless when carrying out status assessments. So you can see the sort of direction of travel. And interestingly, both the DWP and HM Courts and Tribunal Service said that they had relied on HMRC's CESS tool and undertaking their status assessment. So the CESS tool, for those of you who need a reminder, is the Check Employment Status for Tax Purposes tool, which HMRC has created. It was criticised from the beginning for being flawed. It has been sort of tinkered with and some minor changes made. There's been further criticism of it, including by the Economic Affairs Finance Bill Subcommittee, who have issued a report on off-payroll working and the impact of these changes. And there's been a call for a new test to be factored into the CESS tool around mutuality of obligation, but the government is not sort of minded to make that sort of change to the CESS tool. There's also been criticism raised as a result of the fact that in a number of cases, the CESS tool gives an undetermined result. So somebody can go to the effort of plugging in answers to all of the various questions that are asked and then get an undetermined result. And it's thought to be that that happens in around 20% of cases. The government, in response to that criticism, has said that it will provide more comprehensive guidance for cases where undetermined results arise, but no more than that. And you'll also remember that HMRC said that they would allow for a soft landing during the first 12 months of this new regime, during which financial penalties would not be issued for non-compliance. Obviously, that period has now ended, and we know that HMRC is actively checking compliance with the oil and gas sector and the finance sector being at the top of its list. So with the end to that soft landing and a renewed focus on tax avoidance in the labour chain, companies really do need to have a focus on managing their risk in this area. So let's have a look at what we're going to cover today then, starting off with areas of confusion that we're seeing within clients where we're helping them in this area, and within commentary that we're reading more generally. So we're going to have a look at the impact of employment businesses and others in the labour chain, the impact on risk of outsourcing your status assessments, because we know that that's something that lots of people are considering, thinking about who actually is the end user client, and also thinking about the international angle to all of this. We're going to spend a little bit of time thinking about what should end user clients be doing now in terms of audits, and also preparing for any HMRC review, and then finishing off with HMRC's approach to enforcement and risks of other hiring models and outsourcing arrangements. So first complicated issue that we're seeing arising in this area is thinking about that image that we had on the right hand side of the screen, where there's not just the client and the PSC, but there are also others in that chain. And as I said, sometimes it will just be a single entity that's in the chain. Other times you might find that there are a number of entities there. So that entity might be an umbrella company. If you're thinking about engaging an umbrella company to provide you with your off-payroll workers, then that is a safe way to do it, because the risk sits with the umbrella company from a tax perspective. And that's because the individual is actually an employee of the umbrella company. So the umbrella company has just the normal obligations in terms of deducting tax and national insurance as any other employer would have. You might have a situation where you are engaging or where the supplier in the chain is engaging workers direct on a PAYE basis. And there, the important thing to note is that you must ensure that the intermediary, the supplier in that situation, confirms that they will be operating PAYE under agency regulations and that they're not engaging the workers via PSCs. Because if they're going to engage the workers via PSCs, we flip into the next scenario that we're going to come on to. So that's the confirmation that you want to, two confirmations you want to seek from any employment business which is saying that it will engage workers direct on a PAYE basis. And you might also want to consider seeking evidence from that business of their operation of PAYE by way of your due diligence, just to make sure that that all stacks up. If you are in a situation where you're going to be engaged, where the business rather is going to be engaging workers via PSC, so sort of an employment business model, then in that situation, we're in classic off-payroll working territory. So as the end user client, you're going to have obligations under the off-payroll working rules, including, as we've already talked about, undertaking the status assessment in respect of that individual, notifying the fee payer as to what your assessment has been, with the fee payer then being responsible for deducting tax. It's really important that before you enter into these sorts of arrangements that you seek evidence of who is in the contractual chain. And that is because you might have a situation where you're engaging with an employment business, but actually they then outsource fee paying to somebody else. You want to make sure that you understand exactly who is in the chain and which role everybody has and who's responsible for doing what, and to make sure that you've got appropriate contractual protection. For example, that the fee payer will deduct the PAYE if directed to do so and account to that to the revenue. One of the issues that we've seen is that businesses have moved quite quickly in order to get these alternative arrangements in place, and sometimes even the arrangements have started before the contractual terms have been signed and reviewed. And the employment businesses are then perhaps slightly less willing to agree to changes to their standard form terms than they would have been if it had been a condition of them winning the work that they make those changes. So ideally, you would be asking to see the contractual terms at the point where you're negotiating the pricing, and making any requests for adjustments at that point, rather than trying to do that later down the line. But be wary of the fact that these employment businesses are invariably using standard form terms, and not all of them that we've seen are covering the risk from an end user client's perspective in the way that we would expect if we were acting for the end user client. So just be alive to that and make sure that a thorough review is conducted. And at this point, enough from me, and I'll pass on to Karen.
Thanks, Fiona. So as Fiona mentioned earlier on in the slides, you may have taken the decision to outsource the actual status assessment itself, either because you've outsourced it to one of the entities that are actually providing the workers to you in the first place, or perhaps even just an independent third-party provider who offers that service as a discrete service. There aren't any regulations to prevent this. It's perfectly reasonable course of action to take, and HMRC accept that you might want to do that. But the critical point to bear in mind is that if you do that, it is still the business, which is the end user, that carries the responsibility to take reasonable care. And therefore, if there are any failures in taking that reasonable care as a result of the status assessments which are done, it's still the end user, which HMRC would consider to be liable. So even if you have set up processes with your outsourced provider, which require them to do X, Y, and Z that would satisfy the reasonable care cert kind of level of service, you're still ultimately responsible for any failures. So how can you mitigate against that risk? You might want to ensure that you've got some form of contractual protection for that outsourced service to provide you with a level of service that takes reasonable care, and possibly even provide you with some compensation if that is found to be breached. Critically, you want to make sure that the entity that is providing that status assessment is getting the right information to be able to perform those assessments, particularly if it's you as end user that really understands how that engagement is working. So you want to make sure that the information flow from you as end user to the assessment team is a really good one in providing the right information. Where the outsourced service is actually using their own tool, or a tool that you have acquired from elsewhere and not the CES tool, you want to make sure that you understand what the logic is that sits behind that tool and have access to it, because it may be that you have to explain that to HMRC if they decide to do a compliance review on your business. So make sure you've got the right to understand and get access to information of what the logic is that sits behind your tool. Make sure that you've got a record of what data has been inputted, so that you've got all of that access to that data if you need it for an HMRC review. So you've got all the documents kind of in an area that you can access. Sometimes it is the case that these providers also provide a disputes resolution process. If that is the case, then just make sure that they're on the hook to be providing that process in the times that are required under the legislation. So there are some quite precise timings in that mean you have to have done X, Y, Z by a certain date. So make sure that they're on the hook to do that, and make sure that you're kind of monitoring how that engagement is working. Some services do offer insurance as well against the risks. If you're going to take that up, just make sure you understand what risks are actually being insured, because there is quite a wide variation in that. On the next slide, we're looking at how the international aspects can complicate factors where you might have a contractual chain that has a number of parties, some of which may be not within the UK. If you yourself are an international end user, you don't have a UK presence, such that if you were to employ someone in the UK, you wouldn't actually have to operate PAYE, then it becomes an IR35 risk for the workers, personal service company, or perhaps some other entity in the chain, depending on what the arrangements are. But if you have no presence in the UK, the end user does not need to do anything. If you have an international worker, then you need to try and establish, in the same way that you would if you were engaging them as an employee, whether they're UK resident and whether they're still on the hook for any tax, even if they are non-UK resident, because they are performing UK duties within the UK. So it's possible that the off-payroll workers might apply where you have an international worker. If you're dealing with an international fee payer, then you do need to take extra care, because whilst normally the position is that it's the fee payer's obligation to operate PAYE, if that fee payer is not based in the UK, then that obligation shifts one entity up the chain to the next UK-based entity in the chain. So that might be you as the end user client. So you may have to do the status assessment and also operate PAYE where you're dealing with an international fee payer. So just moving on to the next slide. One area that does cause confusion is where there are contracted out services. And by contracted out services, we're talking about things that are not actually core to your business. So for example, where you've contracted out window cleaning for an office, or operating a canteen, for example, those are quite clearly contracted out services. They're not core to your own business. But there are quite a lot of grey areas that sit between those most obvious examples and situations which are actually part of you as an end user. And that becomes problematic because we don't have a handy tool to establish who the end user actually is and whether somebody is actually properly providing a contracted out service. And the stakes are quite high, because if it is a fully contracted out service, the off-payroll working regulations won't apply to you if you have contracted that service out. So what we need to do is look at the engagement as a whole and take some of the principles that will be looked at by HMRC and try and decide on balance whether you think it is or it isn't a contracted out service. And we've popped down there in the slide some of the things that you might want to take into account, but it's not an exhaustive list, and neither is it a tick box exercise, much like the status assessment itself. I think it would be fair to say that if you performed a status assessment on a contracted out service and it delivered an inside IR35 result, you might question whether it could ever possibly be a contracted out service. But equally, there will be many situations that sit outside that aren't quite contracted out services. So how can you mitigate this situation where there is a grey area? The examples that HMRC give in their guidance are quite obvious. They're fairly clear cut, like the ones I've mentioned at the top. So they're not actually going to give you a huge amount of help. But one thing I think that it is useful to do is discuss with the service provider what their expectation is, because we have seen some situations where both parties have thought that they are the end user and were planning to operate the off-payroll working rules. And equally, we've seen some situations where neither believed that they were required to operate it. So at least have agreement between the two parties and ensure that if you're not the end user, that who you're dealing with is properly dealing with the off-payroll working rules, and get some satisfaction that they've actually gone through a proper process in terms of that, because you can imagine that non-compliance by them might increase the risk that HMRC might be tempted to suggest that it's not a contracted out service and look to impose penalties on your business. What should you be doing now then? You've spent the last year getting ready for the changes, getting them into place. What do you need to be thinking about? This is the sort of stage where you need to be auditing what's been done over the last year. And HMRC will expect audits to be carried out. You want to make sure you know who all of those off-payroll workers are. And what we would recommend is that you try and pick a few examples in order to try and see whether the hiring policies that you've set up are actually being adhered to, whether the tools that you've suggested are used are being applied consistently with your hiring managers. Have a look at those outside IR35 cases and those, where the status has been undetermined or exceptional cases that you've taken for particular individuals. Have a look at those and stress test them and see whether you would come to the same decision based on the facts now. Make sure that you keep a document trail of your audit processes and your retesting, because that will actually be useful if you have an HMRC compliance visit to be able to demonstrate your reasonable care in applying the legislation. And equally, as Fiona has mentioned, there can be some tricky circumstances with employment businesses and other third-party suppliers. So make sure you've reviewed those contracts and check to see that they are still factually correct. They're still providing the service that you're expecting them to provide, and that the off-payroll working regulations impact is still the same as you expected at the outset of the arrangement. And all of that work should stand you in good stead for any future HMRC compliance visit that they decide to take for you. So if we just move on to the next slide, as Fiona mentioned earlier on, we are coming to the end, or we've passed the end of the soft landing. The soft landing was only a kind of half soft landing, because if HMRC had determined that you hadn't taken reasonable care, you probably would not have had penalties and interest, but you would still have had to deal with the tax on any self-assessments or any assessments that you'd taken an off-payroll working view of. And HMRC disagreed. So it wasn't a complete soft landing, but now we're definitely in a penalties and interest regime too. As Fiona mentioned, we've seen some evidence of compliance checks being done, and HMRC has said that they were going to tackle the oil and gas sector and the financial services sector at the outset, because those were two sectors which were heavy users of payroll workers. So what can you do if you are approached by HMRC for a compliance visit to best protect yourself? It is important that you make sure you have a plan in place for dealing with these visits. So do choose who's going to attend them wisely. Make sure that the people who are attending actually do understand what processes you have in place and how they have been followed, because you need to put your best foot forward in these compliance checks and don't want to give evidence of chinks of lack of knowledge that don't demonstrate what you've actually been doing. Do put time into the preparation and have all the documentary backup ready that you might need to show why you've reached certain conclusions and the processes that you have followed. As I mentioned before, make sure you understand the logic of the status assessment tool that you have used so that you can demonstrate to HMRC the reasons why you've come to certain decisions, and where that departs from CEST, make sure you understand those departures and be able to justify them. Similarly, where you've taken exceptional cases, have some evidence of why you've reached those decisions and your case made out so that you can answer those questions robustly when they're asked. It's useful to document discussions you're having with HMRC during these checks, just to make sure that you're happy that what has been discussed is actually what is the output. And demonstrate what approach you have taken to the audit and the disputes process where you have dealt with those. I'm not going to talk about this final slide in any great depth, but just be aware that HMRC have a number of tools at their disposal to be able to shift the liability of non-compliance of tax where there is some element of evasion of your suppliers onto you as a contracting business. They're alive to the risks that are posed by the increase in umbrella companies and other suppliers of payroll services. So where you are dealing with individuals, suppliers, please make sure that you're doing your due diligence and understand who you're contracting with and be comfortable with it, the risk that they may pose, and terminate arrangements if you see any evidence of non-payment of tax, because that will help justify your position with HMRC and should stave off any negative consequences for you.
Great. So we've got just time for probably one question. The next couple of slides, there's just a link to our hub on our website, our IR35 hub. And for those of you who are Workbox by Brodie's users, a reminder that there is IR35 and off-payroll working rules content on Workbox. But Karen, just I guess related to that point that you were just talking about, what is the position if the client has taken reasonable care, but HMRC disagrees with the assessment?
Yeah, it's an interesting one, that, because if you can demonstrate that you have taken reasonable care to HMRC and they agree, that it doesn't necessarily mean to say that they agree with the response that you have or the answer that you have come up with. They still will seek the tax, so the tax is still at stake. And if you have a fee payer in the contractual chain, it's actually their liability to meet the tax. So you may have entered into a contractual undertaking as to who's responsible for that when you're engaging with your suppliers. But it is actually quite a big risk for agents that are the fee payers, where there is an exposure to them, even although they are not the ones that are doing the status assessments. And that is why they have an ability to raise a dispute of an outside IR35 assessment to make sure that they are comfortable with the risk that they are taking on. So yeah, something that is worth bearing in mind as well.
Yeah, no, absolutely. Conscious of the time, it's 1 o'clock on the dot, so we will wrap up there, and thank you all very much for attending.